The lack of a Franks hearing doomed Bryan Kohberger in the Idaho 4 case and doomed Richard Allen in the case of the Delphi case. At least that's what I'm going to delve into today, is how much did the Franks hearing, or rather the lack of a Franks hearing, impact those trials right from the outset? What is a Franks hearing? Let's get into all of the details. The devil's in the details. Let's go. Now, as many of you know, I'm kind of new to the Delphi case, and the Delphi case with Richard Allen should be kind of over. After all, he pled guilty and sentenced to 130 years in prison for the killing of Abby and Libby in Delphi, Indiana. However, a similar thing has appeared on my radar: the Franks hearing. The whole defense saying, hey, let's have a Franks hearing to determine whether the arrest in the first place was legal, whether the search warrant was legal. That Franks hearing, for the entire purpose, is to determine whether or not the prosecution and law enforcement had sufficient evidence to make an arrest in the first place. Because once an arrest has been made, one can argue the system then goes like a juggernaut to convict the person who's been arrested. And that's the way the system works. You don't want to get into the pipeline. If you get your name on the radar and you're in the pipeline, you are almost as good as doomed. Everything ends up in a plea. Almost nothing goes to trial. Once you've been accused, it is pretty much a guarantee you're going to get convicted. At least that's the way many people feel in America. So if you're a person who thinks that there might be some problems with our judicial system and believe in shedding transparency on crimes rather than hiding everything behind unprecedented gag orders, as happened in the Idaho 4 case and in Richard Allen's Delphi, Indiana case with Abby and Libby, then like and subscribe to this channel right now. Make sure you're watching us, because this is what we fight for. We fight for transparency. And at the end of the day, it really doesn't matter to us at the end of the day whether or not the accused really is guilty or not. That's not the point. The point is shady law enforcement tactics, shady prosecution tactics, judges that work with law enforcement and prosecution to get convictions. And if that happens one time mistakenly and an innocent person goes to jail, we've got problems. And that's the basis of the American legal system, is that we would rather for a few guilty people to walk free than for one innocent person to go to jail for something they didn't do. And so let's re-examine again Richard Allen's case and show some similarities to Idaho 4, because everything seems to revolve around the Franks hearing. When a judge says, no, we're not going to have a Franks hearing to determine whether the arrest was illegal in the first place or the search warrant was illegal in the first place, go ahead and make that arrest on half lies, half truths, half evidence, and don't allow anybody to question it. We've got enough to go forward with it. And once we start that process, will more than likely lead to a conviction. Now, I will admit, in Richard Allen's case, which we're going to spend a lot of time on today, I'm going to go back and read the original affidavit for arrest. This was was an affidavit for the search warrant on Richard Allen. Richard Allen had willingly come in to the police station to give testimony about what happened that day years ago. Richard Allen was brought in 2022 for a crime that happened in 2017. He came forward in 2017 when the murders happened and gave his testimony about what he saw that day, and they let him go. There wasn't probable cause for an arrest or a search warrant then, and as his attorneys argue today, there isn't one today. But the judge denied a Franks hearing, which was the defense saying, hey, look, there's no reason for you to have issued a search warrant on Richard Allen in the first place. You didn't have enough information, and the prosecution and law enforcement flat out lied to the judge to get that arrest warrant or to get that search warrant. So that's what we're going to look at today. We're going to go back in time and look at that very, very first affidavit for a search warrant. What did they have on Richard Allen? And I will admit, when I first read through it with open eyes and looking at this case for the first time, I said to myself, holy shit, they got really good evidence on Richard Allen. By his own admission, they've got really good evidence on Richard Allen. Some of that you have to take with a grain of salt, because when you look at what the defense says, when we get to the end of this latter half, if you will, of this particular hour of discovery, you'll see the defense pointed out a lot of shit you didn't hear in the document we're about to read. So let me make sure you're clear what I just said. We're going to look at the original affidavit for search warrant on Richard Allen, what he said that led law enforcement to go to a judge and say, wow, this is our guy. We believe if you give us a search warrant for his house, we are going to find proof of murder. And the judge said, yeah, with what you just told me, that is proof of murder. What the defense is going to argue after you hear this great, compelling argument, and it's going to sound good, and we're going to talk about that a little bit in detail about how bad it does sound for Richard Allen on the original search warrant that the judge said, yeah, fuck yeah, if that's what you got on Richard Allen, go get him. Go get that search warrant, find the evidence of murder, and convict this guy. However, the defense will point out that, well, there was just a lot of things that law enforcement lied to the judge about or admitted to the judge that had the judge known, the judge may not have actually thought that was good enough to go arrest somebody or to search their house. And therefore, had the judge heard the Franks hearing and their argument that there wasn't enough grounds to do the search warrant in the first place, it would have never happened. There never would have been a trial. Richard Allen would never be in jail. Same kind of thing happened again to Bryan Kohberger and Idaho 4. Ann Taylor submitted that we wanted to have a Franks hearing and talk about, hey, that PCA is full of shit. The probable cause affidavit has a whole bunch of erroneous information that's just not true. And if the judge knew all the facts, they would have never agreed to it. And Hippler said in that case, doesn't matter. I don't want to hear a Franks hearing. Good enough. You got him arrested. Go forward. Same thing. Richard Allen, Fran Gull. Hey, defense says, there wasn't enough grounds to make that search warrant in the first place. And she said, I don't care. Go forward and conquer. The lack of having a proper Franks hearing is what is up on the table, in part, in the appeal by Richard Allen's defense team saying, because he did not have a proper Franks hearing, the whole thing should be off the table. Will the same thing carry over to Idaho 4? The lack of a Franks hearing would make the whole thing in question. So let's look at the details. Now let's bring up on screen, after all that talking, the actual original affidavit for search warrant. This is what was submitted to a judge to say, this is what we've got reason to believe Richard Allen is the murderer of Abby and Libby. And this is why we want to go after him. Please give us a search warrant because we believe if we go to his house, we will find evidence of murder. I'm going to read this in its entirety. It's only about 5 pages long, but the devil's in the details. That's what I always say. I hope you've liked and subscribed, by the way, because we're going to have a lot of coverage and we're just getting started. And again, for me, it's brand new. I'm coming at it with some fresh eyes. So all of this may be old news to you, but I think you're still going to get something out of it, seeing how I see it with my fresh eyes today. All right. Carroll County Sheriff Department Detective Tony Liggett swears or affirms that he believes and has good cause to believe that evidence relating to the crime of murder in violation of that code is located at the residence of Richard Allen, date of birth 9/9/1972, located at 1967 North Whiteman Drive, Delphi, Indiana, in Carroll County. Detective Liggett believes that evidence in the form of handguns, a .40 caliber ammunition, knives, blue sweatshirt/jackets, black sweatshirts/jackets, clothing, electronics devices, and a cell phone with the phone number 317-612-4533, and any other cell phones used by Richard Allen will be located on the property. The affiant states as follows in support of the said warrant. So this is now the detective making his case to a judge. This is what we've got on Richard Allen, and this is why we think we're going to what we're going to find at his house if you sign off on the search warrant. On Monday, February 13th, 2017, at approximately 1:50 p.m., Abigail Williams, this is one of the victims in Delphi, and Liberty German, the others, a girl that was, a victim, were dropped off by a family member at the Monon High Bridge Trail off of County Road 300 North. On Tuesday, February 14th, 2017, at approximately 12:17 p.m., the girls were found deceased. Their bodies were located in the woods northeast of the Monon High Bridge. Autopsies of the girls ruled that the deaths as homicides, and their wounds were caused by a sharp object. Investigators located Liberty German's iPhone 6S under her body at the scene and were able to recover a video, approximately 43 seconds in length, captured at 2:13 p.m. on February the 13th, 2017. Now, keep in mind, by the way, Richard Allen is going to be arrested years later. Richard Allen spoke to them on, I think, February 13th, 2017, when the girls went missing. And that's part of the thing. They let him go. For 5 years, he walked as not a suspect until arguably the person who was the lead suspect at the time died in jail for an unrelated crime. And then they switched to Richard Allen as the focus of the investigation, which led many people to believe, hey, what the hell? How come this guy evaded being on your radar for 5 years and was never a no, never mind? And now 5 years later, you come forward and say, hey, this has been the guy all along. We want to go after this guy. after your lead suspect dies. All right, continuing on, however, with the warrant request for Richard Allen and why they're convincing a judge Richard Allen is the guy now. The video that they caught on the girl's phone depicts Abigail walking on the Monon High Bridge towards Liberty, while a male subject wearing a dark jacket and jeans walks behind her. Near the end of the video, the man is heard in the video telling the girls down the hill. Through their investigation of the location of the bodies, investigators also located a .40 caliber unspent round. They also determined that articles of clothing from the girls were missing from the scene, including a pair of underwear and a sock. Sorry for the yawn. All right, now these details matter. The devil's in the details. We're going to get into a lot of things that they're going to say, which sound really, really bad for Richard Allen. And then we're going to start to go, wait a minute. Did the judge know that? All right. Through the investigation, there were interviews done with 3 of the 4 girls that were on the trails that day. So this is where it gets really big. Eyewitness testimony that places Richard Allen there. And I'm going to be fair with you. I'm going to be fair. I like to be fair about both sides. I play devil's advocates with myself on things as well. I have reason to believe Richard Allen wouldn't be the guy, isn't the guy. And yet, when I looked at this, I was like, fuck, even Richard Allen says he's the guy that was there, the bridge guy. Even Richard Allen essentially says, I'm the bridge guy, or at least it looks that way when you read it. It looks like it's flat out what he said. But the devil's in the details, so stay with us because it gets more nuanced. All right. The girls observed. So these are talking about 3 girls or 3 of 4 girls who were out there at the park that day. This is not the victims. This is people who saw quote unquote bridge guy, which many believe is Richard Allen. The girls observed a male on the trails on February 13th, 2017 that matched the description of the male in the video recorded by Liberty German. So again, Liberty caught video footage of a man walking behind them on the Monon High Bridge and the sound of him saying, girls, down the hill. And that was the last anyone ever saw them. And they were found dead shortly after or shortly away from that bridge where he allegedly led them down the hill and killed them. So allegedly the guy that says girls down the hill is the last person who's seen them alive and is the guy that killed them. And that person is Richard Allen. That's the story that prosecution tells us and convinced people of in a court. But is it the whole story? All right. And again, bear with us. All this is about judicial scrutiny, making sure they did it right. And the lack of the Franks hearing is a big, big, big deal. And we're going to get to that as we wrap up today. The 3 girls identified as Rayleigh, is that Rayleigh, Voorhees, Brianna Wilbur, and Anna Spath. I'm sorry for my pronunciations. I'm reading these names. I haven't heard these names because, again, I'm relatively new to the case other than a few interviews I've seen online. So 3 of the 4 girls that they have as eyewitnesses are Rayleigh Voorhees, Brianna Wilbur, and Anna Spath, encountered this male near a bench east of the Freedom Bridge. The girls were on the trail and were walking towards the Freedom Bridge to go home, and the male they encountered was walking from the Freedom Bridge towards the Monon High Bridge. One of the 3 girls, identified as Anna Spath, described the male as an older man walking on the trails as they were leaving, and she described him as kind of creepy. This is, of course, the language that makes it, hey, he looked creepy. Fucking Bryan Kohberger in Idaho looked creepy. Therefore, let's start to convict him because he doesn't look quite right. So here's a person saying this guy looks creepy. Not really evidence, but it's great to put in front of a judge to convince them that they must have done something because they look creepy. In a text from Anna to Kyla Brumet, in a text from Anna to Kyla, and then they pronounce Ann, they write Ann. So I think there are lots of typos, by the way, which makes it even harder when I'm trying to figure out what the hell happened because we went from Anna to Ann. Ann described the man as wearing like blue jeans, this is direct quote, like blue jeans, a like really light blue jacket. His hair was gray, maybe a little brown, and he did not really show his face. And again, his face is Biz face. Typos, it just makes it hard to freaking be very factually correct. Anyways, so this is a person, an eyewitness, who describes seeing a guy leaving the Freedom Bridge towards the Monon High Bridge where the girls were last seen, where the video was shot, saying she saw a man that matches the description of the bridge guy, essentially what they're going to say, who looked kind of creepy, heading that way. Investigator, and then it's all fucked up. Mullen and Brent Ingram interviewed Anna, and she described the male as wearing a blue jacket and light blue faded blue jeans. The jacket was a canvas duck type jacket. Rayleigh Voorhees was also in the group of 4 girls and said that she said hi to the man, but he just glared at them. See, again, he's creepy looking and he glares at people. This is great language for posing that this is something ominous. And it may have been that way. Don't get me wrong, but this is language specifically designed to plant in your mind something's wrong with this guy. He looks creepy and he glared at the girls and he didn't talk back to them when they said hi. She recalled him being in all black and had something covering his mouth. Rayleigh recalled telling her sister that someone was in a grumpy mood. She went on to describe him as not very tall and bigger build. She said that he was not bigger than 5'10". Rayleigh went on to say in an interview that he was wearing a black hoodie, black jeans, and black boots. She said that he had his hands in his pockets. Now, already we have some problems because wearing all black is not the description of the bridge guy. We'll get to that in a little bit. All right. An interview was conducted in 2020. So again, the murders happened in 2017. An interview was conducted in 2020, years later, of Bree Wilbur. She's one of the girls that were there that day that said she saw this guy. She was able to show investigators a picture years later that she took on her phone of the Monon High Bridge with a timestamp of 12:43 p.m. Eastern. Now, this starts to lock down very, very important critical details. She's got a picture she can show investigators of the guy or whatever she said she saw that day. Bree showed investigators another picture she took at the bench just east of the Freedom Bridge when they say that they were leaving at 1:26 p.m. And the girls are believed to be murdered somewhere in that 2 to 3 time frame. Everything's lining up. Girls got dropped off around 1:30. Here they're seeing the guy around 1:26, same time. Everything's lining up very, very well. And to be frank, it looks bad. By the way, Frank is pun because this whole thing is about Frank's hearings. Bree stated after she took the picture at the bench, they started walking back towards the Freedom Bridge. Bree stated that's when they walked past the man who matched the description of the individual in the picture. Detective Liggett believes the picture that she is referring to is the picture that law enforcement released of a man on the bridge taken from the video that Libby captured on her cell phone on the day of the murders. So again, investigators think that we've all seen this photo that Bree provided of the guy who ends up being the bridge, identical to the bridge guy who is captured on the girl's phone, if you're following so far. Bree described the man as wearing a blue or black windbreaker jacket. She stated the jacket had a collar and they had a hood up from clothing underneath the jacket. Bree advised that he was wearing baggy jeans and was taller than her. She stated her head came up to her head came up to approximately his shoulder. Bree told us Riley said hi to the man, and he said nothing back. Bree described the man as walking with a purpose, like he knew where he was going. Bree also stated the man had his hands in his pockets and kept his head down. She didn't get a good look at his face, but believed he was a white male. All right, so far, so good. Eyewitnesses place a man at or near the Monon High Bridge at exactly the time that the girls are dropped off at the Monon High Bridge and last seen by a guy who matches a physical description of the same one that these girls on the path say they saw that day just before the girls went missing. Everything looks really, really good and really, really bad for Richard Allen so far. And it gets worse. Let's continue. As the girls, it gets worse. By the way, I need to clarify. When I say it gets worse, it's not like I have a dog in the fight to say Richard Allen is innocent, and so it looks worse. It looks worse for Richard Allen, right? If you're going to maintain innocence, that he didn't do it and he had nothing to do with it, it looks bad for Richard Allen. But let's not forget, Richard Allen never said he wasn't there. He repeatedly said, yeah, I was there that day. I saw girls there that day. He saw these girls there that day. All right. As the girls left, they crossed the Freedom Bridge and the railroad bridge over Old SR 25. An individual by the name of Betsy Blair. So now we've got another eyewitness. Again, all of this is great. It's pinpointing exactly what happened. Multiple eyewitnesses, 4 girls up on top. Another girl named Betsy Blair sees it. A whole bunch of people saw this encounter right before the girls went missing. So it's nailing down great, great details and looks bad for Richard Allen. So an individual by the name of Betsy Blair was returning to the trails to finish her walk. Betsy Blair is seen on video at Hoosier Harvest Store, on 300 North, and I'm probably pronouncing that wrong, 300 North, traveling eastbound to the trailhead to park at 1:46:20 actual time. Blair saw the girls walking above. So she's down below on a trail. She sees the girls walking above as she went under the railroad bridge. So she's down below. The girls are up high on the bridge. She sees the girls at this time, 1:46:20 actual time. On September 21st, 2022, so again, years and years later, Detective Liggett was provided a tip narrative from their tip system to review. They said, hey, by the way, after one of our lead suspects in the case died, we need to go back and look for new suspects. So now they look back in the system and they go, hey, there's this old tip. That's what's basic. Again, I'm providing narrative while reading it to you on screen. The reason why I've got it on screen is so that you can try to separate when I'm clarifying things for you and adding details to what's on screen. So you can see on screen what parts I'm adding in. If you're listening at home, unfortunately, or listening on the radio and you're not watching, unfortunately, you're going to get confused between what was actually said and what I'm adding for clarification because you don't get the benefit of reading along. This is a visual medium after all. All right. But that doesn't mean that you can't get something out of listening to the audio. All right. So this tip that was given to Detective Liggett to re-review was from DNR Lieutenant Dan Doolin, and the narrative is follows. And here's the big quote. This is the tip from way back in the day. Mr. Allen, now we're talking about Richard Allen, was on the trail between 1:30 and 3:30. He parked at the old Farm Bureau building and walked to the new Freedom Bridge. While at the Freedom Bridge, he saw 3 females. He noted one was taller and had brown or black hair. He did not remember description, nor did he speak with them. He walked from the Freedom Bridge to the High Bridge. He did not see anybody, although he stated that he was watching his stock ticker on his phone as he walked. He stated there were vehicles parked at the High Bridge trailhead, however, did not pay attention to them. He did not take any photos or video. His cell phone did not list an IMEI number, but did have the following, and then they give some information on his phone. And then there's a question in the tip, potential follow-up information. Who were the girls walking in the area of Freedom Bridge? Well, we now know. We know those 3 girls were Bree and all those other people that were listed up above, and that we saw their statement. But now think about this. We've got a lot of really good connection points. Mr. Allen himself claimed that he was there, that he saw 3 girls, just 3 to 4 girls or whatever, just like the ones that said, we saw that guy. They all admit they saw each other there. He admits he didn't talk to the girls. The girls said that he never talked to them. Everything's matching up. He had his head down. He says he was looking at his phone. They said he wasn't talking. He had his head down. All of these things match up and look really bad for Richard Allen. It seems clearly Richard Allen is the guy the girls saw and vice versa. So the question now becomes, is he Bridge guy? Is he the guy Libby sees on the phone? And Libby and Abby see. Through the statement of Mr. Allen, he admits that on February 13th, he parked his vehicle at the, quote, Old Farm Bureau building from 1:30 to 3:30 and was on the trails at that time. Now, here's the kicker that makes him look really bad to a judge. There is no Old Farm Bureau building, in quotes, anywhere close to the trails or bridges. So what they're telling a judge is Richard Allen lied. Richard Allen told them he parked near the Old Farm Bureau building, but when they looked, there is no such thing as an Old Farm Bureau building anywhere near. Richard Allen lied. That's what any judge is reasonably going to hear. Detective Liggett believes that what Richard is really referring to, and I'm paraphrasing here, is the old Child Protective Services building. In 2017, Richard Allen owned. So what they're saying is Richard Allen did park near a building, but it wasn't the Old Farm Bureau building because there's no old Farm Bureau building. There's actually a Child Protective Services building, and that's where the detective thinks Richard really parked. But they're kind of implying that he lied about where he was parking by giving the wrong name of the building. Anyways, putting that aside for a minute. In 2017, Richard Allen owned a 2016 black Ford Focus and a 2006 gray Ford 500. So he owns 2 vehicles. Upon review of the video collected from the Hoosier Harvester so that's a camera, right? A video camera that they've got that they're calling the Hoosier Harvester. On February 13th, investigators were able to locate a vehicle that appears to match Allen's 2016 Ford Focus on the video at 1:27 actual time. So they show a car that appears to be also in the Idaho 4 case is consistent with. That's the words they like to use. They like to use those words because they know that it's not definitive. They're not saying we saw his license plate number. We're not saying anything. They're saying that it looks like and is consistent with. It's language to say it could be or it couldn't be. But they're leading the judge to find that, hey, look, we saw a vehicle that appears to be the vehicle that we're looking for. This coincides with Allen saying that he was at the trails around 1:30. So they see on camera a car that looks to be the same as Richard Allen's car, and he admitted that he was there at that time. Therefore, reasonably, anybody can conclude it is indeed Richard Allen because he said he was there, and we see a car that looks like his there. Good enough. We don't have to prove it actually was. Any reasonable person conclude if he said he was there and we see a vehicle that looks like him, it's good enough. All right, I'm beating a dead horse. Devil's in the details. That's why it's in the appeal. It's in the appeal. So that's why I'm focusing on it. It's not like I'm just making you focus on it for no reason. It's in the appeal. Detective Liggett then examined the timeline for the day of the homicides. As previously said above, Rayleigh Voorhees, Brianna Wilbur, and Anna Spath were leaving the trails and passed by a male matching the description of the male in the video taken by Liberty. Given the statements by Allen and the timestamp of the video from the Hoosier Harvest Store and the statements from the three of the four girls, Detective Liggett believes that the male the three girls saw was in fact Richard Allen. And I get it. I get it. When I read it, I was like, fuck, that's bad for Richard Allen. He said he saw three girls. Three girls said they saw him. He matches the description maybe of the bridge guy. He's kind of fucked. This is good info for those who believe Richard Allen did it. But story's not over. Allen stated that after he passed the girls and then he walked to the Monon High Bridge and saw nobody else, investigators believe that after passing the Hoosier Harvest Store at 1:46 p.m., Blair, that's the other witness that was down lower and saw the girls up above, parked at the trailhead entrance across from the Mears residence. In her interview, she says there were no other cars at the trailhead entrance at that time. She walked to the Monon High Bridge and a male matching the male from Liberty's video. The grammar is bad, so I'm not sure what that was supposed to say. She described him as a white male wearing blue jeans and a blue jean jacket. This matches the blue duck canvas jacket that Anna Spath describes. Blair said that the male was standing, should be standing, lots of typos in this search warrant, on the first platform of the Monon High Bridge, approximately 50 feet away from her. Blair, this is the eyewitness, turned around at the bridge and continued her walk. Approximately halfway between the bridge and the main hub of trails, she passed two girls walking towards the high bridge. Blair said that she believed that was Liberty German and Abigail Williams. So these are the victims. So this girl sees the guy that we're saying is Richard Allen at the Monon High Bridge just before seeing the two girls coming towards the bridge as well. So now she places everybody at the same place. And so things are looking very, very bad for Richard Allen. At 1:49 p.m. on the Hoosier Harvest video, there is a white car that matches Kelsey German's vehicle. Kelsey German is Libby German's sister, who dropped them off at the park that day and then left. So this woman, this eyewitness, says she sees Kelsey German's vehicle leaving. Liberty and Abigail would have been dropped off right before this video. So she's got it on video. Or they've got it on video, what looks like Kelsey leaving after she's dropped off the girls. Blair finished her walk and is seen on the Hoosier Harvest video leaving westbound at 2:14 p.m. So this eyewitness who says she saw all those things is also captured on camera leaving, and everything is lining up. It looks really, really bad for Richard Allen, and it's going to get worse. Blair said that she saw no adults other than the male on the bridge. As Blair was leaving, she noted a vehicle was parked in an odd manner at the old Child Protective Services building. This is the same one they said that Richard Allen said was the old Farm Bureau building. She said that it was not odd for vehicles to be parked there, but it was odd that it was backed in near the building. She said that vehicles often use the south edge of the parking lot so they are closer to the trail to get to Freedom Bridge. So he wasn't parked next to the trailhead, and he was backed in instead of forward parking, which she thought was odd. Detective Liggett reviewed a tip from a Terry Wilson. So another tip had come in. He's going back and he's looking, trying to find more evidence. Wilson, this other's tip, was on his way to Delphi on February 13th on the Hoosier Heartland Highway at approximately 2:10 p.m. He observed what he described as a purple PT Cruiser or a small SUV type vehicle parked on the south side of the old CPS building. So this is another person placing that car at that building at that time. Wilson said that it was backed in, so he's corroborating the other eyewitness, as to conceal the license plate of the vehicle. I myself start to wonder why this person thought a person was trying to hide the license plate. Did he already know a murder had taken place when he gave this testimony? And so therefore he's already trying to find, well, I think it was suspicious. They were trying to hide it. Whatever the case may be, he believes that he saw a car parked there like this other person, and it was backed in like the other person. And he thinks that means they were trying to hide their license plate. During their interviews, both Blair and Wilson drew a diagram and had the vehicle that they say parked in the same general area and manner. So again, this is the arrest warrant written for a judge to say, look, we've got like 5 eyewitnesses here that place Richard Allen there and or his car right there. And they even drew pictures of where his car was. So can we go get this guy and arrest him? Because we believe we're going to find evidence of murder. And so you can't necessarily blame the judge for saying, yeah, based on what you've got, it looks really, really good. And it gets worse. An interview was done of Sarah Carbaugh in 2017. So again, this is back during the time of the disappearance. She states that she was traveling east on 300 North and observed a male suspect walking west on the north side of 300 North, away Monon High Bridge. Probably means away from Monon High Bridge. Again, there's so many typos in this thing, it's hard to tell, and I don't want to interject what they were trying to say, but I'm guessing that's what it is. She stated that he was wearing a blue-colored jacket and blue jeans and was muddy and bloody. She further stated that it appeared he had gotten into a fight. Investigators determined from the video that she was on 300 North at 3:57 p.m. So after the time of the murders, when the girls stop moving, according to what they know, they see a man, an eyewitness sees a man leaving in muddy, bloody clothing who appears to have gotten in a fight. And any reasonable judge would say, well, shit. You got a bunch of eyewitnesses that see Richard Allen there with the girls at the right time. And then after the girls start moving, you see him in a bloody, muddy configuration, leaving the scene of the crime. Any reasonable judge or anybody in America would presume that's the same guy. So we go on. Richard Allen was interviewed by investigators on October 13th at the investigation center. This is where it gets even worse. He was interviewed by Detective Liggett and Carroll County prosecutor investigator Stephen Mullen. He agreed to come to the center and speak with investigators. So he willingly agreed to go talk to the investigators about this. Keep that in mind. He willingly went there. He was advised of his rights, and he was further advised that he was not under arrest and he was free to leave at any time. Investigator Mullen explained to him how to leave the center if he so desired. So in other words, they're telling him not only are you free to go, they told him how you could leave. Like, this is how you can get up and walk out of here. If you want to walk out of here, you're not under arrest. You can leave at any time. He voluntarily gave up this information, which they're going to use as evidence somehow of guilt. And we're going to say is evidence of, man, he came forward on his own. Why would he do that if he was the killer? But let's keep going. He stated that he was in fact on the trails on February 13th, 2017. He further stated that he saw 3 girls on the trail east of the Freedom Bridge, and he also that he went on to the Monon High Bridge. He also told investigators he was wearing blue jeans and a blue or black Carhartt jacket with a hood on it that day. He stated he also wore some type of head covering. He further claimed that he saw no one else but the 3 girls and he observed east of the Freedom Bridge. Further, prior to the interview, he told investigators that he also had guns at his home. So holy shit. Holy shit. Richard Allen came in and said, I saw the 3 girls who saw me. They said I didn't talk to them. I didn't talk to them. Everything that Richard Allen is saying matches what the eyewitnesses say. How can it be anybody other than Richard Allen? And I'm not saying it's not. I'm not saying it isn't somebody other than Richard Allen. But the devil's in the details. Stay with us. Richard M. Allen's wife, Kathy Allen, spoke to investigators as well, and she confirmed that Richard Allen did have guns and knives at the residence. She also stated that Richard has a blue Carhartt jacket. So they're listening. Look, all the things we're looking for, because we found a bullet at the crime scene and he's got a gun. The girls were killed with knives, and him and his wife say they have knives. He was seen wearing a blue jacket. His wife says, and he says he had a blue jacket on that day. It's all lining up, Judge. And any judge would say, yeah, looks pretty good. Go see if there's more evidence. So they continue. The evidence gathered shows that on February 13th, that 4 girls, Rayleigh Voorhees, Brianna Wilbur, Anna Spath, and Isabel Voorhees, were on the trail when they observed a male individual walking on the trails toward the Monon High Bridge. The male was wearing clothes similar to the clothes of the male depicted in the video taken from Liberty German's phone. Investigators know that this male is last known individual to have contact with Liberty German and Abby Williams before they were murdered. Further, Betsy Blair, another eyewitness, was shown a picture of the individual on the Monon High Bridge, and she says that is the same individual that she witnessed on the trails on that bridge. So again, they showed a picture that, Bree had of this guy on the bridge, and she's like, yeah, that's the same guy I saw on the bridge. In an interview with Richard Allen done on October 13th, 2022, so this is years later, an interview done with Richard Allen in 2022, he admits that he was in fact on the trails on February 13th and walked past 3 girls and continued on to the Monon High Bridge. He stated that he was physically on the bridge. After Betsy Blair sees this individual, there are several other individuals on the trail that don't observe the man or Liberty German or Abby Williams. Sarah Carbaugh then observes a man walking down 300 North with a blue jacket and jeans on, and that he is muddy and bloody as if he had just been in a fight. She is shown a picture of the man on the bridge, and that is the same man that she observed walking on 300 North. I mean, bam. They got him. I mean, bam, right? It looks bad. When I read this, I was like, well, fuck. How do you argue that? But I had the benefit of reading the appeal before I read this, and I know what they're going to counter with. Investigators believe that Richard Allen is the last individual to have made contact with Liberty German and Abby Williams. Investigators further believe that Richard M. Allen is the individual depicted on the Monon High Bridge from the video taken from Liberty German's phone. And we're almost done with this document, and then we can move on to the appeal in a little bit more detail to get to what their argument was. Detective Liggett has been a member of law enforcement. Now, this is where they get into, again, fuckery. And this happened in the Idaho 4 case. What they do is they tell you all the reasons why criminals act the way they do. They're not saying Richard Allen did these things. They're saying this is what criminals do, and this might be what Richard Allen did, and therefore Richard Allen might be a criminal. But they do it in a very clever way. In my experience in law enforcement, I know that criminals do X, Y, and Z. It appears that Richard Allen did X, Y, and Z. Therefore, it appears Richard Allen is a criminal. So here's how this works. Detective Liggett, and they did the same thing with Bryan Kohberger. Criminals turn off their cell phone before going to a crime scene. Bryan Kohberger turned off his cell phone before driving to the crime scene. This is consistent with what criminals do. It's only half the story. All right. Detective Liggett has been a member of law enforcement for 21 years. In his role as a deputy and detective, he has investigated numerous crimes, including murders. He has also been trained in how to investigate offenses, such as murder. He also has participated in training specifically geared towards murder investigations. In many of those cases, evidence of the crime is on individuals' cell phones. That evidence includes location evidence in relation to the offense, pictures or videos taken during or after the offense, and evidence in furtherance of the crime or in an effort to hide their participation in the crime. Detective Liggett has had an opportunity to review the evidence collected in the investigation. Detective Liggett knows from his training and experience that when individuals commit offenses, evidence of those offenses in the form of pictures or location data is captured on an individual's cell phone. Detective Liggett also knows that individuals tend to download their phones to other electronic devices or use their cell phones in conjunction with other electronic devices, including iPads and computers. Detective Liggett believes the information gathered from witnesses, video evidence, and admissions by Richard Allen is reliable. Richard M. Allen places himself at the trails and specifically on the Monon High Bridge. He further admits that he was wearing jeans and a dark Carhartt jacket. These clothes match the clothes by the individual on the bridge in the photo taken from the video from Liberty German's phone. Detective Liggett was able to corroborate the information that Richard Allen was at the trails near the time that Liberty German and Abby Williams, and that just kind of drops off. So I think they meant to say when they disappeared or died or whatever. The picture of the individual on the bridge was captured by investigators from the video taken on Liberty German's phone just prior to her and Abigail Williams being abducted. The individual in that picture matches the description of Mr. Richard Allen. Detective Liggett believes that Mr. Allen is the individual on the bridge. From Richard Allen's statements, investigators believe that Richard Allen was also on his phone when he was on the trail prior to meeting the girls. And yes, Richard Allen said he was watching his phone ticker, his stock ticker on his phone. So, based on all that, I believe that a search of the residence located at 1967 North Whiteman Drive, Delphi, Indiana, located in Carroll County, as well as the outbuilding, the vehicles, and property, will lead myself and other investigators to evidence of murder. I have probable cause to believe that there will be evidence located on the property of this offense. Due to the aforementioned reasons, a search warrant is being requested to enter the property of Richard Allen, date of birth, located at, and ordering law enforcement to seize any evidence that is related to murder. So that's it. That's the search warrant. And one can argue that any judge presented with that great piece of writing, that evidence, even I who read it said, well, fuck yeah, go get him. Looks like you got him. It looks like you got the guy. Any reasonable person would conclude that. I agree. But now let's get into what a Franks hearing is and what it does, which is challenging whether or not the statements made to the judge were factually correct or not. That's what we're talking about. A Franks hearing is what that judge heard that led them to say, fuck yeah, go get him. You got the right guy, go get him. You have probable cause for days. Go get that guy. But did the judge get told the truth? Was the judge lied to? Did the judge get misled? And if so, that's a violation of the law. So here's from the appeal recently filed in Richard Allen's case after he was convicted of those murders, because here's the argument. Once you went for a search warrant, it was inevitable that you were going to convict somebody. That's the way our system works. It's a juggernaut. Once you arrest somebody, it's game on until they get him prosecuted and in jail or accept a plea deal, as in maybe the case of Bryan Kohberger in Idaho 4. So let's get into the argument and some legal nuances. We'll try to finish this up in about 20 minutes so that you can get on with your day and move on to another, whatever the hell it is we're due. All right. The trial court erred. This is the defense's motion. The trial court erred by concluding that Detective Liggett did not make false statements or reckless omissions in his affidavit. So what they're saying is the judge trusted the detective that he wasn't making any false statements, and that was a mistake. And here's why. They first point to the law. Both the state and the U.S. Constitution guarantee that no warrants shall be issued but upon probable cause supported by oath or affirmation. The state must include all material facts in a warrant application, including facts that cast doubt on the existence of probable cause and a source's reliability. So it's not good enough to present half the fucking story to a judge. Only the part of the story that would lead any person to go, well, yeah, if that's what you've got, go get him. So what they're arguing is this paragraph right here. Not only do you have to have probable cause, but the judge has to have seen if there was any information that would lead them to question your probable cause or the reliability of the witnesses. That's the part the prosecution and the detective seeking the warrant didn't give to the judge. Those things that would have led a judge to go, wait a minute, maybe that's not very reliable and we need to rethink this. That wasn't allowed. That would have come out maybe in a Franks hearing. Hey, here's what they didn't tell you, judge. That whole warrant was wrong. Let's have a Franks hearing to determine whether the probable cause was met. That's what Ann Taylor tried to do in the Idaho 4 case. Let's have a Franks hearing to determine whether or not they really could identify suspect vehicle 1 in Idaho 4. Did they really do their due diligence, or did they lie about the cell phone records, saying that Bryan Kohberger switched off his phone and was pinging off the cell tower that services that? All of that shit was what Ann Taylor said. Let's have a Franks hearing. And Judge Hippler said, no, we're not going to have a Franks hearing. I think it was good enough. I don't need to hear your argument. Fran Gull, in this case, said, no, we're not going to have a Franks hearing about whether or not they misled the judge into getting that warrant. I think it's good enough. The lack of having a Franks hearing let them proceed to trial or to prosecute the case. And in one case, get a conviction through trial. And in another case, get a plea deal that may not have happened if the whole arrest and probable cause wasn't sufficient in the first place. That's the gist of this video and the gist of this argument made by the defense. So let's get into the details. They continue to explain the law. An officer omits evidence with reckless disregard if the officer withholds a fact in his kin that any reasonable person would have known that the judge would wish to know. So if you can look at what they withheld from the judge, and any reasonable person would be like, well, fuck, the judge probably should have known that when they were making the decision whether to give a search warrant. That's what the basis is. If a reasonable person would say, well, if the judge knew that fact, they may have reconsidered, then you've got a problem. So now they're going to tell you why any reasonable person would have thought the judge should have known pieces that they left out. Examples include, for example, undermining the type of drug that was seized or an informant's reliability. If you hide from the judge that the informant's not reliable, or you're going after cocaine, but they really had marijuana and you just say drugs and you mislead them on what type of drug it was, those are material facts that make a difference. If you mislead the judge into thinking it all sounds good on paper, but you're kind of misleading them, that's illegal. These include details undermining an officer's conclusions. The detective misled the court by incorrectly reporting a witness's description of a suspect, equating description with the defendant. So in other words, the detective provided evidence over and over to the judge that eyewitnesses consistently described who they saw there that day as the defendant, Richard Allen, and so therefore we should go get him. What they didn't tell the judge is that not everybody saw the same person, and the descriptions disagreed quite a bit, and they left that all out because they didn't want the judge to hear that there was any question. They wanted the judge to think there was no question. Everybody saw the same guy. There was no question. Had the judge known that there was multiple conflicting eyewitness testimonies about who it was and that people changed their opinions and changed their story over time, that might have made a difference to a judge. Detective Liggett omitted and changed key information that undermined his conclusion that Allen was the bridge guy. So here's his argument, the defense's argument. Liggett misled the court in 4 ways. First, Detective Liggett misled the court to believe that Blair, that's one of the eyewitnesses, description of the man on the bridge matched Allen when it did not. Listen. The defense is saying, in that search warrant, he says, Blair gave a description of the guy that was there, and it matched Richard Allen. The defense is saying that is a lie. That is not true. So let's talk about it. Liggett told the court that Blair said the man was standing on the platform and wearing a blue jacket and jeans. And then they cite that reference. But Liggett omitted the rest of Blair's description that did not match Allen. She said the man had brown poofy hair like the sketch below, was in his 20s or early 30s, youthful and a medium build. So again, Detective Liggett only told the judge the part of the story that matched, blue jeans and a jacket, and failed to mention that she said he was a young guy in his 20s or 30s with poofy hair, not a gray-haired guy with a thicker build. All the things that would have said, wait a minute, that's not the same description of the defendant, left that out and only told the judge the important clothing description that made it look like the same guy. That's omission number 1, that any reasonable person would think the judge should know that they had a completely different description of the age and appearance of that male. Second, Liggett misled the court that Allen's car was parked at the old CPS lot during the time of the kidnappings. Detective Liggett told the court that after Blair saw the man on the bridge, she saw 2 girls that she thought were Abby and Libby on the trail approaching the bridge. And they cite where that's at. As Blair was leaving the trail, she saw a car oddly parked at the old CPS lot. Around 2:10 p.m., another witness, Wilson, also saw a car backed into the CPS lot, as if concealing their license plate. We heard all that. Both witnesses drew diagrams of the car parked at the same general area and manner. So they're just stating the facts that were stated in that search warrant, but here's what they didn't tell you. Liggett told the court that Allen parked his black 2016 Ford Focus at the old CPS building, but omitted that Blair said the car she saw during the time frame of the kidnapping was not black and had sharp angles like the sketch below. Considering the omitted information, Blair excluded Allen's black hatchback. So, listen. Blair gave a description of a black car that had sharp edges like this right here. Betsy Blair, that's her diagram. Hard, sharp edges, black car. And so they were like, well, he doesn't have a black car and his car has rounded edges, and her description excludes his black hatchback. That was a material omission, is what the defense says. Material omission, something that should have been mentioned. It's not true that both of those clearly identified Richard Allen's car there, because they disagree on the shape and the color of the car. Third, Liggett misled the court that the man walking on 300 North was the bridge guy. He misled the court, saying that the man walking at 300 North was the bridge guy. Liggett falsely told the court, lied, is what they're saying. Liggett, the detective, lied to the court that Carbaugh, an eyewitness, in 2017, claimed the man was muddy and bloody, wearing a blue jacket, when what she actually said was his jacket was tan and he was muddy, period. There was no mention of blood. There was no mention of blue. It was a tan, muddy jacket originally. And Detective Liggett lied and told the judge that what was described by Carbaugh was a man who was muddy and bloody and looked like he had just gotten into a fight, which was apparently not true. They continue on. A bloody man in a blue jacket matches bridge guy. A muddy man in a tan jacket does not. So a judge might have said, well, wait a minute. That's not the same guy. Or it could be reasonably thought that that's not the same guy. I'm not sure. Liggett also admitted that Blair told him the man she saw on the bridge was not the same person that Carbaugh has described. Listen, Liggett omitted that Blair themselves told him the man she saw on the bridge was not the same person that Carbaugh described. So you have witnesses saying, nope, that's not the guy. And Detective Liggett just failed to tell the judge that witnesses were conflicting about whether or not they saw the same guy. ISP, and in this case, it's not Idaho State Police, because ISP is all over our Idaho State case. ISP here is Indiana State Police, even released a public statement that the men are not the same person. Listen, Idaho State Police even released a public statement saying these are not the same guy. But the detective, Liggett, told the judge, everyone sees the same guy. This is the guy, even when they were saying it's not the same guy. It's fuckery. Just tell a judge half the story, enough to get a search warrant, and then we'll just start the juggernaut in process. Same kind of fuckery in Idaho 4, in my opinion. And then fourth, Liggett connected Allen to the bridge guy by falsely claiming that Allen admitted that he was wearing a black or blue Carhartt and a head covering. So, wait a minute. Isn't that what Richard Allen said? Now the defense is saying, no, Liggett connected the bridge guy by falsely claiming Allen admitted to wearing a black Carhartt. Wait a minute. I thought you told us flat. Well, let's talk about it. The man the four girls saw wore the same clothes as the man on Libby German's phone. The clothes Allen admitted he wore matches the clothes by the individual on the bridge in the photo taken from the video. That's all according to that arrest warrant. But Allen told investigators he did not know what he was wearing. And they cited the actual exhibit of Allen's interrogation and cited the timestamp at 44 minutes in which Allen said he couldn't remember what he was wearing. So it wasn't true that he told them, I'm wearing the clothes you've got on that picture, because he told them he didn't remember what he was wearing that day. But they're saying, oh, he admitted he had those clothes on. No, said he wasn't sure what he was wearing that day. Although Liggett used Allen's wife's testimony or statement that Allen currently owned a Carhartt as a nexus to his home, Liggett omitted that she said he had purchased the coat a couple of years ago. Oh, so Liggett used Richard Allen's wife saying, yeah, my husband owns a blue Carhartt kind of coat that he bought a couple of years ago. The problem is, and they pointed out here, the girls were killed in 2017 and he was arrested in 2022. A couple of years ago, it'd be 2020, 3 years after the girls were murdered. So if he bought the coat a couple of years ago in 2020, then it wasn't it was the coat he was wearing in 2017 because he's only owned the coat for a couple of years. And yeah, could somebody be wrong about whether a couple of years or 5 years? Sure, they could be wrong about that. But I bet you could go after and look for purchase receipts and when the coat was. And if you wanted to do some real detective work, you might be able to find out how old the coat was. But it doesn't matter because you want to be able to say, look, Richard Allen owns a blue coat and that's what he was wearing that day. And even his wife said he had a blue coat. So we're going after the blue coat. Doesn't matter if he only owned that blue coat after the murders. Had the court known, this is the conclusion there, had the court known Allen simply admitted owning a blue or black coat, he does not, as does probably every 50-year-old man, it would have known that there was no connection between him and the bridge guy. So any reasonable judge might have said, well, convicting somebody because they own a blue coat isn't enough. Or going after somebody for an arrest warrant or a search warrant isn't enough just because they own a blue coat, because everybody owns a blue coat. It's not, we don't go give search warrants to everybody that has a blue coat. Detective Liggett's omission and false statements recklessly misled the judge. So we're going on with the argument. We're going to finish up here in the next probably 7 minutes. Any reasonable person would have known the judge would wish to know the following: that Blair's description of the bridge guy and the car at the CPS did not match Allen or his car. That that in 2017, Carbaugh described the man walking down the road as only muddy and wearing a tan jacket, not that he had a blue jacket like the bridge guy. The judge also would have liked to have known that Blair did not believe she saw the same man as Carbaugh. The judge probably would have also liked to have known that Allen never said he wore a blue Carhartt or head covering like the one in the picture of the bridge guy, and that he bought his blue Carhartt a couple of years before 2022, and therefore didn't admit to having the coat when the girls were murdered. Those omitted and false information strikes at the heart of Liggett's conclusion that Allen was the man on Libby's phone. The state's probable cause relies on a tight timeline, making Allen the man that the 4 girls saw on the trail, Blair saw on the bridge, and that Carbaugh saw on the road. Any judge would want to know if witnesses described someone other than Allen, his car, or the bridge guy. Moreover, the fact that Liggett twice lied in the affidavit about the connection between Allen and the bridge guy and the blue jacket shows more than reckless disregard for the truth. The falsehoods were directed at connecting Allen to Libby's video, which would otherwise include any white male. So yes, they're doing it's like in the Idaho 4 case. Well, a car consistent with that of a Hyundai Elantra was seen circling the neighborhood. So therefore, that means it's him driving around, and go get him. Even if they have reason to believe it's not the same car. Just tell them it's consistent with. Somebody with a blue coat, consistent with the coat that Allen, they must mean he was there. It's fuckery. And then this point. With the omitted and accurate evidence, the affidavit was insufficient to establish probable cause. Probable cause exists when there is sufficient evidence to cause a reasonable, prudent person to believe a search will uncover evidence of a crime. A reasonably prudent person would not believe Allen was connected to the murder or that evidence would be found in his home. The state is left with Dolan's report claiming that Allen told him he was on the trails between 1:30 and 3:30 and saw 3 girls, not 4, like the others who thought they saw a bridge guy. So again, by the way, there were 4 girls. Bree and her friends were 3 other friends. There was 4 girls, and Allen said he saw 3 girls, not 4 girls. So there's another material problem with how many people saw each other. During his October 13, 2022 interview, Allen admitted wearing blue jeans and owning a gun, knives, and a blue or black jacket and walking out to the platform of the bridge to watch fish. But Allen does not look anything like the person Blair saw on the bridge. Also, his car is different in color and shape from the oddly parked car, and the man Carbaugh saw walking was most likely not even the bridge guy. If Allen being on the trail within the same 2 hours as the girls were abducted is enough for a warrant, law enforcement would have obtained one for his home in 2017. Listen, that's another big point. If it was enough for him to have just been on the trails at the same time as the girls in 2017, when they knew he was there on the trails because he said so, they would have gotten a warrant at that time. But they knew it wasn't enough grounds for a warrant. Just being in the same general area as the girls is not enough for a warrant. They knew that then. What's changed? All that's changed is eyewitness testimony has changed. In 2022, Indiana State Police had no more evidence connecting Allen to the murders than they had days after the murders when Allen, like others, responded to their request for help. It was not enough then, and it's not enough in 2022. And then it says, we're requesting a reversal. A court must suppress fruits of an illegal search, and they cite the law. The state's entire case is built on Liggett's half-truths and falsehoods. Without the gun seized in the search, there's no opinion from Kohberger upon the state on which the state arrested Allen. Because again, they had in the details, the devil's in the details. The bullet found at the crime scene matches your gun is sketchy science. It's in the documents. It's sketchy science. But without the gun in the first place being seized from his home in an illegal warrant, they wouldn't even be able to have used sketchy science to tie him to the scene. So that's their whole argument. They're like, look, if you didn't go get his gun illegally, you wouldn't then be able to use sketchy half science to try to say that it's his gun that left the bullet at the scene, which, by the way, a bullet was not even used in the crime. The girls weren't shot. It was just an unspent round found there, which they claim through some sketchy science, I think, that it's his bullet. It may or may not be, but it's sketchy science and it's not reliable. Even if this court finds the confession was not a product of solitary, because again, while in solitary confinement, Richard Allen eventually broke after 13 months of solitary confinement and said, I guess I killed those girls. I guess I did it. And so that was the confession that was used in part to convict Richard Allen of the murders because he broke in solitary confinement. So they're saying, even if the court finds that his confession was not the product of solitary, meaning he was broken as a man and confessed to something he didn't do, and they think that, hey, look, he really did do it. It's not just his confession. He really did do it. Allen is still entitled to a new trial. Before the constitutional error can be held harmless, the court must find that it was harmless beyond a reasonable doubt. Without the fruits of the search, the gun, the casing in a hope box, the Carhartt, the knives, and the computer, the state cannot prove the jury would have convicted. If you didn't have all that extra evidence, that it's all circumstantial, like it is in the Idaho 4 case, if you didn't have a mountain of circumstantial evidence, if you didn't start down the witch hunt process of this is our guy and we're going to find anything we can to make it look like he did it, if you hadn't started that process, nobody would have convicted him. At a minimum, Allen is entitled to remand for a Franks hearing. And this is what the subject of the whole video is about, the Franks hearing. Even if Allen's exhibits to the Franks motion did not prove by a preponderance of that Liggett deliberately or recklessly falsified or omitted material information, they entitled him to a hearing. So what they're saying is, even if you disagree that the detective lied or omitted things that a judge would have wanted to hear, that should have had a chance to be shown to a judge in a Franks hearing. A defendant who makes a substantial preliminary showing that an affidavit included a false statement or reckless omission necessary to probable cause is constitutionally entitled to challenge the warrant at their hearing. By a Franks hearing, you're entitled. When there's even possibly a reason to believe that somebody lied, misled, used half evidence to convince the judge to go for the jury, they're entitled to a Franks hearing. And in Richard Allen's case, the judge said, no, you're not entitled to a Franks hearing. In Bryan Kohberger's case, Hitler said essentially, no, you're not entitled to a Franks hearing. He heard very, 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 very limited stuff. Anne had a whole bunch of shit that she wanted to discuss at the Franks hearing. And he said, no, we're only going to talk about one item only. And it was one that they'd already lost. He essentially told them no Franks hearing. Gull said no Franks hearing. And what they're saying is, even if you have a slight possibility that somebody lied or omitted about the basis for the arrest, you have to have a Franks hearing. But both judges denied the Franks hearing. And therefore, both judges, in my opinion, shaped and started a juggernaut system that is designed to convict by denying somebody of a Franks hearing. Here, the court's denial of a hearing was legally erroneous because Allen made a substantial showing. He made a substantial showing that they lied and gave half-truths to the judge. Allen supported his claims with depositions, police interviews, and reports. Citing Liggett's application, Allen made specific arguments. In a final motion, Allen reiterated these points, arguing that the court to compare the affidavit with Blair and Carbaugh's interviews to show that these two people were changing their testimony and didn't match up. Tellingly, the trial court was willing to schedule a Franks hearing only when Allen was represented by Fort Wayne attorneys, but refused to when his original attorneys were reinstated. Oh my God. Last point of fuckery for today. Richard Allen had a couple of attorneys. The judge fired his own attorneys, threatened that if the attorneys did not step down themselves, she would have them removed and she would appoint her own attorney or put somebody else in her place. Somebody, by the way, that she had more personal relationships with. She made that move. She fired Richard Allen's attorneys and put somebody in place that had personal connections to her, in everyone's opinion, really. And then it had to get overturned and his original attorneys were reinstated. Fran Gull was only willing to hold a Franks hearing when she had an attorney representing Richard Allen that was favorable to her. But when she was forced to reinstate his original attorneys, all of a sudden, once again, the Franks hearing's off the table. That kind of bullshit should make you wonder what the fuck's going on in this case. So as a conclusion, I want to say, if you find these kind of deep dives interesting and entertaining, if you've learned anything today about Franks hearings, if you have started to question now whether or not prosecution and law enforcement tells half-truths to judges to obtain search warrants and probable cause by only telling half the story, and whether or not a person will ultimately be convicted or forced to plead guilty to something because the system, once it's put in place, is out of control and is leading towards convictions. If you think any of that's possible, watch our show, like, subscribe, follow the Idaho 4 case, follow the Delphi case, follow the Mickey Steins case, follow Rex Kierman's case, follow Luigi Mangioni's case. We cover a bunch of them. And every single night we have Crimes After Dark, 6 p.m. Pacific Standard Time, where a panel, including law enforcement, EMT, former EMT person, firefighter, EMT. We've got attorneys that come on the show. We've got deep thinkers. We've got a great panel that discusses this from many, many different angles. We keep our open mind. Again, I want to reiterate, whether Richard Allen is guilty or not is not even the point of these stories. Whether Bryan Kohberger is guilty or not is not even the entire point of these exercises. The exercises is to open up our closed and hidden court systems in America, where they hide shit and tell half-truths to judges, to start a system in place to convict people. And if they get it wrong one time, God help us all. Thanks for listening. Have a great day.